Good afternoon, and thank you all so very much for being here today. My name is Gabrielle McBee, and I'm presenting Liberty Woods International, Inc., the MV Ocean Quartz. This is a decision out of the Third Circuit about forum selection clause violating Section 3.8 of COGSA. The facts are fairly straightforward. As one may expect with a case involving COGSA, the issue arose when goods that were carried by sea were damaged. In this instance, it was a cargo of plywood that LWI had purchased and shipped to New Jersey. The plywood sheets were loaded on board the Ocean Quartz, which was owned by Dahlia Shipholding. They bareboat chartered her to Star Bulk, who time chartered her to Daiichi, who time chartered her to SK Shipping. SK Shipping issued a bill of lading with a forum selection clause that selected the Seoul District Court in South Korea as the forum in which to bring disputes. Predictably, when the cargo was offloaded in New Jersey, it was found to be damaged, and LWI threatened to arrest the vessel. Instead of arresting the ship, they accepted a letter of undertaking, or LOU, from the vessel's insurer, Japan Ship Owners Mutual Protection and Indemnity Association. The LOU guaranteed any judgment against the Ocean Quartz in rem in an amount up to $2.75 million. LWI then proceeded to file suit in the District of New Jersey against the vessel in rem and against Dahlia, the owner, in person. However, they could not recover against Dahlia because of the bareboat charter party. LWI admitted that they could have brought a suit against SK Shipping in personam in South Korea. However, they felt that they would not be successful and refrained from doing so. The Ocean Quartz then moved to dismiss the suit in rem because of the forum selection clause. LWI argued that the forum selection clause violated COGSA 3.8 by relieving the carrier of liability, since South Korea does not recognize NREM suits. The district court granted the Ocean Quartz's motion to dismiss, and LWI appealed. On the issue of foreign forum selection clauses in bills of lading, historically they have been looked at unfavorably, based mainly on the en banc Second Circuit decision of Inducive Court v. SS Ramborg. The court in that case reasoned that litigating in a foreign forum presented too high of an obstacle to enforcing liability due to the costs involved with such litigation. However, that view shifted dramatically with the Supreme Court decision in Sky Reefer, in which the court held that foreign arbitration clauses did not violate COGSA. In that decision, the court differentiated between the liability imposed upon the carrier due to their negligence and the means of enforcing that liability, i.e. the ability to bring an NREM suit. The Fifth and Ninth Circuits followed the Supreme Court's lead in Mitsui & Co. v. Mira NV and Fireman's Fund v. Choyang Shipping, respectively. The Fifth Circuit held that the Sky Reefer decision was not restricted to only foreign arbitration clauses, but foreign forum selection clauses as well. Both the Fifth and the Ninth Circuit highlighted the Sky Reefer line of reasoning, that there is a difference between the liability of the carriers and the means of enforcing that liability, and that COGSA is only a statutory guarantee of the liability and not the means for enforcing such liability. So in the case at hand, the Third Circuit joined the Fifth and the Ninth Circuits and held that foreign forum selection clauses, which select a foreign forum where NREM proceedings are not available, do not violate COGSA 3.8. Again, the court here really focused on that distinction between the statutory imposition of liability via COGSA and the means of enforcing that liability. They point to the fact that LWI had obtained an LOU guaranteeing an NREM judgment. So if they had used that LOU, the vessel's liability would not be lessened in violation of COGSA 3.8. LWI tried to argue that NREM suits are critical features of maritime law and therefore should not be avoided, and that because such suits were excluded from 3.8, the foreign forum selection clause choosing a forum which does not recognize NREM suits should be void. The court was unpersuaded. Because the U.S. is one of the few jurisdictions that does recognize NREM proceedings, if every forum selection clause that chooses a forum that doesn't recognize NREM suits was voided, commerce would be greatly impeded. So policy would dictate that such forum selection clauses should be allowed. Further, to use the court's language because it is so succinct, the argument that absence of express limitations grants a substantive right is woefully inadequate. The Third Circuit further pushed back pretty strenuously against invalidating the clause because LWI had obtained an LOU from the vessel's insurer. Since LWI could have collected on an NREM judgment under the LOU, the liability was not lessened. The court held that LWI had limited its means of recovery by not pursuing an in personam suit against SK Shipping or securing an LOU that covered in personam judgments, as the vessel had argued. In a concurrence, Judge Ambrose raised an important question about the scope of the holding and pondered how a judgment against an asset could be enforced against a party who does not own the asset. His concern lay in the fact that the vessel is typically the main asset on which a creditor can rely to collect from a foreign defendant. So in the instant case, LWI could have enforced a judgment against the value of the vessel, had in rem proceedings been available. But in a different case, an owner could denounce liability found in an in personam action against a subcharter who is several steps removed. In such a case, the liable party could become insolvent or have assets not worth the amount of the judgment, and the claimant would not be compensated. Judge Ambrose further posited that if the party who bears liability is hidden somewhere in a chain of chartering, like the one present in the case, problems could exist in a case where a forum selected by the bill of lading places the liable party outside of in personam jurisdiction. So in analyzing the case, what really stood out to me was that this really provided a warning and a guideline for how to obtain an LOU when a dispute occurs. The Third Circuit kind of was beating the dead horse throughout their decision by repeatedly saying that LWI had limited their means of recovery because they had not obtained an LOU that covered in personam judgments, and they chose not to pursue in personam suits against SK Shipping in South Korea. In one respect, it does fall on LWI to cover their bases, as it were, when trying to recover their losses. However, the Third Circuit really focused on the fact that they could have pursued litigation in South Korea, and they did not take into account the cost and effort associated with litigation in a foreign country and a foreign legal system. This is also where Judge Ambrose's concurrence starts to come into play, because a foreign legal system may not recognize the LOU, or the party issuing the LOU may not actually be the responsible party. And one common problem that comes up with LOUs is that the issuer will omit an insurer's obligation to cause the vessel owner to defend against an in personam action when the in personam party does not own an interest in the ship. A chain of chartering could put a party beyond the reach of the chosen forum's jurisdiction. So COGSA 3.8 may in fact be violated by a foreign forum selection clause in these instances, and the holding in this case would not be applicable. So that was really the main takeaway, to be cognizant of the forum that is selected in bills of lading in a contract, and make sure that you obtain LOUs that cover both in rem and in personam judgments, or else your client is going to be the dead horse that the Third Circuit is beating. And finally, the Third Circuit did fall in line with the Fifth and Ninth Circuits in holding that foreign forum selection clauses do not violate COGSA 3.8. All of these circuits have ruled that in rem suits are not a procedural device guaranteed by COGSA. They rely heavily on the Sky Reefer reasoning that there is a distinction between statutory liability imposed on ship owners by COGSA and the means of enforcing that liability. However, an Eastern District of Virginia case called Alliance Insurance Company v. Choyang Shipping Company shows that there is at least one judge out there who has decided that in rem suits are a procedural device guaranteed by COGSA. In that case, the judge held the exact opposite of the Third, Fifth, and Ninth Circuits rulings and said that COGSA 3.8 does in fact grant in rem suits as a substantive right. The judge reasoned that Section 3.8 of COGSA would lack substance if in rem actions were merely an unprotected procedural device. The suit in rem was ultimately dismissed, and the Fourth Circuit did not review the issue on appeal. However, the holding suggests that other judges, courts, or circuits may find that in rem suits are a statutorily guaranteed right, and if that were to occur, there would be a circuit split that would need to be resolved. So that's a summary of the noted case, which serves as a useful guide for what security you should seek in an LOU when a foreign forum selection clause in a bill of lading selects a foreign forum that does not recognize in rem suits. Thank you all very much for your time.